Friends, in this video I am going to discuss the law-making power of the executive. Indian constitution is unique in the sense that unlike other constitutions, it has expressly granted legislative power to the chief executive. Normally, executive legislation, except in the form of delegate legislation, is opposed to democratic principles. Other constitutions like US, Canada, Australia, and even UK do not empower the executive to exercise legislative power. Interestingly, the Indian Constitution by Articles 123 and 213 confers on the President and governors respectively the power to issue ordinances which are in the nature of legislation. During the recess of the Parliament and the state legislatures, this power of promulgating ordinance can be exercised. At the center, since the legislative power is vested with the Parliament, the power to issue ordinance for a limited period can be exercised, as I have already told you, when situations may arise to take urgent legislative action, that is, in exceptional circumstances. Article 123 provides that two conditions precedent are to be satisfied before an ordinance is promulgated by the President. They are: both houses should not be in session. This is the first condition, that either one or both houses of the Parliament should not be in session, which makes it impossible for a single house to pass and enact a law. A house is said to be in session when it is neither dissolved nor prorogued. Adjournment by the Speaker or the Chairman of the House does not entitle the President to promulgate an ordinance because an adjourned House is considered to be in a session. An ordinance may be promulgated just a day or two before the date on which the Parliament is scheduled to meet. Satisfaction of the President is the second condition. That is, the second condition to be fulfilled for issuing an ordinance is that the President should be satisfied that circumstances exist that require immediate actions on the part of the President. The Apex Court has not yet defined the phrase satisfaction of the President, and even whether the subjective satisfaction of the President can be questioned in the court of law. To clearly clarify the said ambiguity, Indira Gandhi-led government passed the 38th Constitutional Amendment Act in 1975, which had expressly excluded the subjective satisfaction of the President outside the purview of judicial review. But the 44th Amendment Act of 1978 deleted this clause, holding that the power of President could be challenged in a court of law if it is based on bad faith, corrupt motive, or had any mala fide intention. Let us now know the duration of an ordinance. That is, what is the duration of the ordinance? The justification for ordinance is that a law is immediately needed when the Houses of Parliament are not in session. Therefore, once the Houses are in session, there is no justification for the continuance of the ordinance. Thus, under Article 123, Clause 2 of the ordinance, the ordinance may come into an end in three ways. First, the President may withdraw the ordinance. Secondly, it may be disapproved by the Parliament. And thirdly, it may lapse if it is not ratified by the Parliament within the stipulated period. When the Houses of Parliament reassemble, the ordinance has to be laid before the respective Houses of the Parliament. The ordinance ceases to be operative if it is disapproved by passing resolutions by the respective Houses of the Parliament. If the resolutions disapproving the ordinance are passed by two Houses on different dates, the ordinance becomes inoperative from the latter of the dates. Even when resolutions disapproving the ordinance are not passed, the ordinance automatically lapses after 6 weeks from the date on which Houses reassemble. If the Houses reassemble on different dates, then which date is to be reckoned? The period of 6 weeks is to be reckoned from the latter of the dates. Then let us consider what is the status or authority of the ordinance. Article 123 provides that an ordinance shall have the same force as an act of parliament, and the power of president is coextensive with the power of parliament to pass law. So, the president cannot promulgate an ordinance on an item in state list and cannot transgress the fundamental rights. Can the president amend the provisions of the constitution through an ordinance? The answer is no. The president cannot amend the constitution by an ordinance, as the amendment is outside the ordinary legislative process. Further, the president cannot authorize the withdrawal of money from Consolidated Fund of India through an ordinance. The ordinances may have retrospective effect and may modify or repeal any act of parliament or other ordinances. It may be used to amend a tax law also. Now, whether the ordinance making power of the president is subject to review by the courts, the answer is yes. In the case of A.K. Roy versus Union of India, decided in 1982, the Supreme Court, while examining the constitutionality of the National Security Ordinance of 1980, which was issued to provide for preventive detention in certain cases, opined that the President's power of making ordinances is not beyond the judicial review of the court. However, the court was unable to explore the issues of the case further, as the ordinance of the President was replaced by an act. The Supreme Court also pointed out in this case that the need to exercise judicial review over the President's decision would be only on substantial grounds and not otherwise at a very casual challenge. In the case of R.C. Cooper versus Union of India, the constitutional validity of the 25th Amendment Act of 1971 was challenged, which curtailed the right of property of an individual and permitted the acquisition of the same by the government for public use on the payment of compensation, which has to be determined by Parliament and not by the court of law. So the said case, popularly known as bank nationalization case, the apex court, while examining the constitutionality of Banking Companies Ordinance of 1969, which had sought to nationalize 14 commercial banks in India, it was held that President's decision can be challenged on the ground that no immediate action was required on his part. Next, in the case of T. Venkata Reddy versus State of Andhra Pradesh, decided in 1985, the Supreme Court considered the question whether the ordinance passed can be tested upon the similar grounds as those on which an executive or judicial action is tested. In answering the question, the Supreme Court cited its own earlier judgment given in K. Nagaraj versus State of Karnataka, decided in 1985, and held that the power of making ordinance is a legislative action, so the same grounds as related to the law making should be challenged than challenging the executive or judicial on judicial grounds. Further, in the case of S.R. Bommai versus Union of India, the scope of judicial review was expanded, and the court held that where the action by the President is taken without the relevant materials, the same could be falling under the category of obviously perverse, and the action would be considered to be in bad faith. The Supreme Court held that the exercise of power by the President under Article 356, Clause 1 to issue proclamation is justiciable and subject to judicial review to challenge on the ground of mala fide. In the case of State of Orissa versus Bhupendra Kumar Bose, the Supreme Court held that the rights and obligations which are created by the ordinance came into effect as soon as the ordinance is promulgated, and the same cannot be extinguished until a proper legislature by a legislative body extinguishes those rights and obligations of the ordinances. In this context, a reference to the case of D.C. Wadhwa versus State of Bihar decided in 1987 is quite appropriate, as promulgating and re-promulgating ordinances by the Bihar governor was challenged. In this case, there is promulgation of ordinances and the same were then re-promulgated. Between the year 1967 and 1981, 256 ordinances were promulgated and then re-promulgated, and some among them remained in existence for up to 14 years. In this case, Chief Justice P.N. Bhagavati observed, I quote, "The power to make an ordinance is to meet an extraordinary situation, and it should not be made to meet political ends of an individual. Though it is contrary to democratic norm for an executive to make a law, but this power is given to the President to meet the emergency, so it should be limited in some point of time." Unquote. The Supreme Court held that successive promulgation of ordinances was a colorable exercise of power and as such a fraud on the Constitution. The court ordered for the payment of rupees 1,000 to the petitioner, a professor who conducted the research and revealed the abuse of ordinance making power by the governor. Thus, the power of promulgation of ordinance is a unique legislative power vested in the President, which can be exercised to meet an extraordinary situation when both the houses of Parliament are not in session. With this, I conclude this presentation. Thank you for listening to the lecture. Thank you.